The Honorable Judge Thomas Steptoe, presiding. Court is now in session. And if you have cell phones, turn them off or turn them on vibrate. Please be seated.
Thank you. This is a case of David V. Taylor versus Michael R. Kelly, case number 12C94. Is Mr. Taylor here?
He is, Your Honor.
In person and by counsel, and your name again, sir?
My name is Charles Crooks. I'm a lawyer from Morgantown, Jackson County, and counsel for Mr. Taylor.
Very well, sir. And is Mr. Kelly here?
He is, Your Honor. He's here beside me. My name is Frank Portman. I'm his attorney.
In person and by counsel.
Yes.
Thank you. Sir, your name?
Good morning, Your Honor. May I please the court? My name is Tim Stranko with the law firm of K. Costello and Cheney. I'm representing the county commission this morning.
Very good. All righty. Gentlemen, I'm Judge Steptoe. I'm a retired circuit court judge in the Eastern Panhandle, and I'm what we call senior status, and I'm one of the pool of judges upon which the Supreme Court will call if there's a need for a judge to stand in a particular case, especially in single judge circuits, where if a judge has an issue that he thinks requires him to stand aside, the Supreme Court can then call upon a retired judge to step in without interfering the dockets of other active judges. So, I believe that this is an appeal from an election contest hearing held before the county court. And if memory serves, I believe that the appeal is to be decided totally upon the papers, filings, exhibits, and issues raised and discussed and decided by the county commission. Is that council's perception?
Yes, Your Honor. It is.
Yes, sir.
With that in mind, I would invite counsel for the petitioner then to proceed. Is it you are going to proceed by argument only? Is that correct?
That's correct, Your Honor.
Okay. I'll recognize you to do so.
Thank you. May it please the court. Your Honor, my name is Charles Crooks. I'm counsel for David V. Taylor. He is petitioner in this civil matter. This case comes before the court today as an appeal by right under West Virginia Code, Chapter 3, Article 7, Section 7. That provision of the code provides procedures for election contests of this kind. This case was originally tried before the Upshur County Commission on July 18 of this year. That county commission body was sitting at the time as an election court. The county election court was charged with the jurisdiction of hearing my client's petition challenging the result of a May 8, 2012 primary election contest, partisan election on the Republican side. The trial was conducted on July the 18th. The entire case was heard that day and was submitted on argument and the record for decision. That decision was rendered on July the 26th, 2012, less than 30 days after submission in accordance with controlling code provisions. My client was entitled to file an appeal by right within 30 days of that decision, we did so. The case is now here in the circuit court with Your Honor sitting by special designation following the recusal of Judge Cadle. This court is empowered to review the record generated below. With respect to the issue of the record, it might serve the court to address that momentarily. There was a audio recording made, I believe, of the trial, utilizing microphones of the kind we have here in the courtroom with us today. I do not believe that has yet been transcribed. There was also a video recording made of the trial, utilizing the services of the same gentleman who is preparing a audio-video recording of this hearing.
Would it be practicable to obtain either a
Type transcript, Your Honor?
well, type transcript probably would require too much time.
There was about 2.5 hours of argument and presentation of evidence.
Well, my thought is that hopefully the decision that will emanate from this judge will be satisfactory to both sides. However, I have to consider the possibility that might not happen. And if so, a party deeming himself aggrieved might wish to present a petition to the Supreme Court in timely fashion. And, you know, there's a question of the preparation of the ballots. The election is only 2 months away.
Some 9 weeks, yes, sir.
And that's what motivated the question about what can be done about getting access to that information. But again, this may be a case where the facts are really not contested, and it's really a question of law. And if that's the case, then a review of the record below is not as critical. Go ahead. I'm thinking out loud.
Well, and I appreciate your thought process. In fact, would endorse your last concept that this record is clear enough. It's beyond any real dispute on the facts, and the error of which we complain is a legal one, which I believe, based on the briefing that's before the court, can be addressed expeditiously and accurately and justly without the need of a typed transcript. However, I would add that my client has posted a bond in the amount fixed by the election court. Presumably, they took into account the cost of preparing that record when they devised that amount. The audio-video recording was submitted with our petition. I don't know if that expedites the process of review or not for the court to have a video recording of a 2.5-hour trial to the bench, but that's in the record. Really the issue, not to belabor the status of our record more than it deserves, Your Honor, the issue here is whether the election court embraced error when it came to a decision that is articulated in the final order that was entered on July 26th and recorded in the miscellaneous record of the county at Book 10, beginning at page 797. According to that final order, the predicate articulated by the election court was erroneous. The court will see at the top of page 719, and for my references, I'm going by the page references found in the public record. This order is not separately paginated. So I'm referring now at the top of page 719. The topmost paragraph indicates that the commission, and the word commission there is used to refer to the county commission sitting as the election court, has no jurisdiction over or power to hear a complaint regarding the Federal Hatch Act. Well, that is true. My client's petition never purported to present a Federal Hatch Act complaint to the County Commission of Upshur County. So to the extent of the first sentence, we agree. Second sentence goes on to say, complaints regarding the Hatch Act are under the exclusive jurisdiction of the United States Office of Special Counsel. Citation is then offered to the Hatch Act. And to that principle, we agree as well. For investigation and prosecutions under the Hatch Act, the Office of Special Counsel has exclusive jurisdiction. However, there is something very important that's being left out in this paragraph, and thus we disagree with the third and final sentence of the paragraph. Accordingly, only matters of West Virginia law are before this commission. That is true, but only to an extent. And allow me to explain what I mean. In my client's petition, we cite a West Virginia code provision which is found in Chapter 7, Article 14, Section 15, subparagraphs A4. Now, Your Honor, that particular statutory provision in the West Virginia Code is part of the Civil Service Act. It applies to employees of the Sheriff's Department in every Sheriff's Department in the state. We cite that because that code citation has two provisions that serve to render a currently serving deputy sheriff ineligible to stand for election of public office in the same county. And the court will find full citation to that code section, including quoted passages in the appeal brief that we filed on August the 27th, as well as in the petition that was filed on May the 25th, as well as our opposition to the motion to dismiss filed on behalf of Michael R. Kelly. That last brief also doubled as a reply in support of David D. Taylor's original petition. So that is all laid out in all those places. And what that code section says is, as a matter of state law, that Chief Deputy Michael R. Kelly, at the time he appeared on the ballot, May the 8th, 2012, as a partisan candidate for nomination for sheriff, was ineligible. That same code section contains a proviso, which we quote in all the documents that I've just recited for the court. That proviso goes on to state very plainly that any deputy who is subject to the Federal Hatch Act may not stand for election.
Period.
Period. Now, the question that arises is whether Chief Deputy Michael R. Kelly, at the time he stood for election on May the 8th, was subject to the Hatch Act. The brief, let me pause here momentarily just to emphasize the point. This is where we take issue with the statement that I quoted to the court a moment ago, appearing at the top of page 719. What the election court did in that paragraph was it obfuscated the provision found in West Virginia Code, which expressly states that a deputy who is subject to the Hatch Act is ineligible to run for election. So to that extent, to the extent that Michael R. Kelly was subject to, not to the extent that he violated the Hatch Act, but just to the extent that he was even subject to the Federal Hatch Act, he was ineligible. So we take issue with the paragraph at the top of 719, which seeks to totally divorce the election challenge from any consideration of the Federal Hatch Act. That's error. Now, at the trial, we submitted exhibits, many of which were pre-prepared and tabulated prior to trial, others which were submitted during the trial itself. The record was recited into the record by the administrator. I hope I don't get Mr. Parker's title flummoxed there, but he recited the exhibits into the record very carefully. I would add that the proceeding that was had before the county commission sitting as an election court was very orderly. This was not a chaotic procedure. I think the record is a very clean one and easy to understand. So I compliment the county commissioners for their service as election court judges. Alas, I have to cite and come to this court for review of their legal error. Now, the record included many different documents demonstrating that federal funding came into Upshur County throughout the time that Chief Deputy Michael R. Kelly was employed as the Chief Deputy. And in fact, it was acknowledged in response to our petition. When Chief Deputy Michael R. Kelly filed his brief in response to the petition, he admitted that he was employed as the Chief Deputy. He also stated affirmatively, in the nature of an affirmative defense, Your Honor, if you will, a plea in avoidance, to use the concept from the common law pleading days, given that this is an action in equity under a statute that creates a right that did not exist at common law. He pled in avoidance and argued in his brief that his violation of the Hatch Act was unintentional. And he attempted to invoke language found in a decision rendered by the West Virginia Supreme Court of Appeals. It was the Sowards case. And we cite the Sowards case extensively in the briefing that was submitted to the county election court, and we reprise that in the appellate brief that was filed with this court on August the 27th. The problem with the Sowards decision is simple. The court in Sowards was reviewing an election contest under an old version of the Civil Service Act. The version of the Civil Service Act that was invoked by my client's petition was revised in 2007. Your Honor, the opposition brief that we filed responding to the motion to dismiss that was served on behalf of Michael R. Kelly, that same brief that served as our reply is in further support of our petition. That combined brief was filed on July the 12th, 2012, the same day that Michael R. Kelly tendered his notice to the county officials here in Upshur County declaring that he was withdrawing from the election. That brief goes through in a very painstaking process and demonstrates that the statute construed by our state Supreme Court in the Sowards case was substantially revised in 2007. And the language that is at issue in our case was not reviewed, was not considered by the Sowards court. And in fact, the entire trial conducted on July the 18th, 2012 found no contest over the fact that Chief Deputy Kelly had been serving in the capacity as Chief Deputy since 2005. There was no objection to the submission of all our documentation demonstrating the flow of federal money into Upshur County. Those documents demonstrated that Chief Deputy Kelly performed work that was connected to the supply of federal funds. In other words, he billed time to programs that were at least in part underwritten by federal dollars, which made him subject to the Hatch Act. He didn't have to be the sheriff. He didn't have to be the appointed director or manager of any of those programs. He merely had to perform work in connection with those programs. And there were a great many of them identified for purposes of the record. His counsel made no contest of that fact. Instead, he, that is to say, Chief Deputy Kelly's counsel, stuck with the original concept, which was to argue the old superseded statute, as well as an Attorney General opinion seeking to interpret the superseded statute. Obviously, both authorities that have no further precedential value for our case. Likewise, he argued that by his withdrawal from the election on July the 12th, his client, Michael R. Kelly, rendered the election challenge moot. The argument proceeded as follows. Ignore the fact that the certification rendered by the County Commission on May the 18th was timely challenged by the filing of a petition within 10 days of that certification. Ignore that, because that defeats his argument. So he has to proceed a couple of steps past that. He argues that his client won the election. Well, it is true he got some 61% of the vote. My client, I believe, got 31%. I may be off a percentage point or so, but that is where Chief Deputy Kelly's argument begins, that he got more votes than David D. Taylor did in the primary election. That result was certified by the County Commission pursuant to law. He, that is Michael R. Kelly, withdrew from the election on July the 12th. Therefore, a vacancy in nomination resulted. And in cases of vacancy in nomination, reference is then made to Chapter 3, I believe it's Chapter 3, Article 5, and Section 19, which says that the vacancy in nomination is to be filled by the executive committee for the partisan party at issue. In this instance, it would be the Upshur County Republican Executive Committee. Well, that argument falls down as a matter of law because there was a timely election challenge filed in this case on May the 25th, 2012, less than 10 days after the certification was filed on May the 18th. I analogized that during the trial to a sporting event. In fact, I drew upon a couple of sporting events, one being football, where it would appear that a play has resulted in a touchdown. And then the coach for the defending team throws a little red flag, and everything comes to a stop. The review is conducted on video, and then the review referee tells everybody, both the teams and the spectators, whether the call on the field stands or whether it's being reversed. I also analogized the legal effect of our timely petition to a horse race, where you may go to a horse race and hold a ticket and you think your horse has won, only to hear the announcer tell everyone in the venue to, ladies and gentlemen, please hold your tickets. Sometimes a horse will be disqualified for one reason or another. And in both of those instances, there is a result achieved. And in this case, an election challenge, if that certification that was entered on May the 18th was found to be defective by virtue of Michael R. Kelly's ineligibility to be on the ballot, then there would be no vacancy in nomination, because the balloting is still available to the county commission to declare that the candidate in the field who garnered the most votes among eligible candidates, that would be David D. Taylor, should be and is in fact the appropriate winner of the contest.
Excuse me, am I to understand from what you're saying that the results of the primary election relative to this race have not been finally certified?
No, they were certified on May the 18th, and under the West Virginia Code, Chapter 3, Article 6, Section 6, we filed a I'm sorry, I misquoted there. That's Chapter 3, Article 7, Section 6. We filed a timely petition within 10 days. That's a very narrow time window, but we're talking about elections, and so time is important. It isn't long from the conclusion of the primary until the general election occurs. So any defect in the primary has to be dealt with quickly. So the code says you have 10 days to file a timely challenge. We met that. And thus, the certification is subject to correction. There has been no final. Now, had we not appealed the July 26th final order entered by the County Commission sitting as an election court, had we simply, let that time period for filing an appeal run without making a timely filing, then the certification May the 18th would have, by that default, would have become the final certification. And then, once it was final, the subsequent withdrawal of the elected nominee would have created vacancy in nomination. Under Chapter 3, it would have required the recognition by the State Election Commission, which is part of the West Virginia Secretary of State's office. They would then notify the Executive Committee for the Republican Party in Upshur County, and then they would proceed to appoint someone. In fact, Your Honor, that process was invoked. There's been a gentleman by the name of, what's Mr. Kaufman's first name? David Kaufman. My apology for forgetting the gentleman's first name. David Kaufman was appointed by the Executive Committee to fill what was taken by the County Executive Committee for the Republican Party to be a vacancy in nomination. Of course, that process and that appointment took no legal notice of the fact that my client had filed a timely petition which was heard. He got an adverse result and has made a timely appeal as a matter of right to this court. So, in fact, I think Mr. Kaufman may be here today. You had the pleasure of shaking his hand, I think, before we started. So, everyone's on notice. Everybody knows that this case has been challenged as a matter of right to this court for decision. The error that was made below was in the finding that Chief Deputy Kelly was not subject to the provisions of 71415A4, which I have cited to the court. Now, the withdrawal, let me speak to that for a moment. The withdrawal of Michael R. Kelly from the election happened on July the 12th, 2012. He filed papers with the county notifying the officials here that he was withdrawing. That is recited in the final order that is before Your Honor. Subsequent to that notification on July the 16th, 2 days before our trial, a letter was sent to the State Election Commission advising them that Michael R. Kelly had previously given notice on July the 12th to the county that he was withdrawing. It was that filing of the 12th followed by the notification to the State Election Commission on the 16th that prompted the Election Commission to proceed and notify the Executive Committee for the Republican Party here in Upshur County to appoint a replacement. Conceivably, if Your Honor were to rule against my client today, then the outcome there, barring an emergent appeal to the state Supreme Court, would be that Mr. Kaufman would be the Republican candidate appearing on the ballot November the 6th, 2012. The withdrawal bears mention for another reason. When Michael R. Kelly withdrew from the race, he did that in response to a letter that is in the record, a letter that came from the Office of Special Counsel that is charged with the exclusive jurisdiction for investigating and prosecuting Hatch Act violations. The OSC was notified by my client of Chief Deputy Kelly's candidacy on the primary ballot. My client not only complained of that fact under the Hatch Act, but he also asked for an advisory opinion from the OSC as to the propriety of Mr. Kelly continuing as the nominee. Sometime after my client filed his complaint with the OSC, Mr. Kelly, through his counsel, wrote a letter to the OSC asking the Office of Special Counsel for an advisory opinion. And the consequence of that complaint and 2 requests for guidance, the response came in the form of a letter that I mentioned. It was dated June the 21st, and it was addressed to Mr. Kelly. I obtained it from Mr. Kelly's attorney as part of our pretrial preparations. And the letter said, and it's in the record for Your Honor to see, it said that Michael R. Kelly, as the Chief Deputy for Upshur County since 2005, was in fact subject to the Hatch Act. Now, that letter went on beyond that point and said that in the view of the Special Counsel, he was not only subject to the Hatch Act, but he was in violation of it when he appeared on the primary ballot, and that he was continuing to violate the Hatch Act so long as he remained a candidate in the election. That letter gave Mr. Kelly an ultimatum. He could resign his position as the Chief Deputy, and if he stayed with the Sheriff's Department, he would have to find some position that was not in any way connected to federal funding, thereby taking himself from under the auspices of the Hatch Act. Or, in the alternative, he would have to withdraw from the election. And they set July the 5th as his deadline. His lawyer asked for and was given a week's extension on that deadline, which fell, obviously, on July the 12th. And that was the day that Michael R. Kelly filed his notice with the county saying that he was withdrawing. Now, that is significant for a couple of reasons. One, what we have is the prosecutorial authority, the OSC, the body that has the exclusive jurisdiction under the Hatch Act to perform investigations and prosecutions, coming to a finding and making a finding and notifying Michael R. Kelly that he was in fact subject to the Hatch Act. That bears relevance to the provisions found in West Virginia Code 71415A4, which says that provided any deputy who is subject to the Hatch Act may not stand for public office, may not stand for election. So, there you have the sole body with the jurisdiction to investigate and prosecute, establishing that prong, if you will, of our case stated in the petition. One that was really admitted anyway by way of the written response that was filed. That plea and avoidance that, yes, it was an unintentional violation in an attempt to invoke that old Sowers decision is a judicial admission anyway. So, we've got 3 different avenues of proof to demonstrate that Chief Deputy Kelly was subject to the Hatch Act. One was his judicial admission 2 was the finding of the Office of Special Counsel, and 3 was the additional evidence that we went ahead and put into the record during the trial. Now, the last consequence to Mr. Kelly's withdrawal is that it took him out of the case. After Chief Deputy Kelly withdrew from the election on July the 12th, he had no further interest in the litigation. No matter what happens after that with the election challenge, it will not have any impact on Chief Deputy Kelly. He has no standing, Your Honor. At the trial, I objected to Chief Deputy Kelly and his attorney's participation in the case, just for that reason. The court overruled my objection. That was error. They manifested the error by embracing the canard that was advanced on behalf of Chief Deputy Kelly, which is he is not subject to the Civil Service Act, and his withdrawal from the race created a vacancy in nomination. Both of those legal principles were embraced by the election court, and they are both clear legal error. So, Chief Deputy Kelly has understanding in this case. I object respectfully, and I'm sure the court and Mr. Hartman understand me when I say that I object, I renew my objection to the participation of Chief Deputy Kelly and his counsel in these proceedings. He has no standing, he has no voice in this dispute any longer. The issue of whether Chief Deputy Kelly is subject to the Civil Service Act. I would offer a couple of things in that respect. And Your Honor, I beg the court's indulgence at this moment because I believe one of the documents that was submitted into evidence during the trial that was not part of my tabulated submission was a copy of a order that was entered November 18, 2008 by the Upshur County Deputy Sheriff's Civil Service Board. And in that decision of November 18, 2008, a decision was made as to whether Chief Deputy Kelly was entitled to credit for his services previously rendered as Deputy Sheriff of the county during the period 1981 through 89. Apparently after 89 he terminated employment with the department. I believe he may have moved out of the area and then later returned and resumed employment with the department, and he wanted credit for that previous time that he had served. And it ultimately resulted in a proceeding before the Civil Service Board. Well, don't you know that the Civil Service Board ruled in his favor? And that decision in his favor, granting him recognition and credit for his prior time, was approved by the County Commission by 2 affirmative votes and none negative. So that was finalized November the 21st, 2008. That is a point of fact as much as law that I point out to this court. You know, for someone who had no standing under the Civil Service Act and could not be found ineligible, Chief Deputy Kelly was nonetheless claiming entitlement to benefits under that very same act when he returned and became the Chief Deputy. Moreover, Your Honor, the Civil Service Act. This is not a civil service case, but we have to go to the Civil Service Act because that's where the disqualification provision for public election is to be found. My client and I did a little analysis of the Civil Service Act, and what we found was that the provision, the Civil Service Act, I should say, contained the term Chief Deputy 9 different times. At least twice, the Civil Service Act talks about all deputies. In 5 other occasions, the phrase "any deputy sheriff" is used. Most dispositive of all of this entire issue of whether the Civil Service Act applies to Chief Deputy Kelly and therefore bars him from eligibility to stand for election is a provision in that code that speaks directly to chief deputies. That is Chapter 7, Article 14, of course, Section 13. That provision of the code, again, 7, 14, 13. The title alone gives away where we're going with this. The caption for that section reads, "Vacancies filled by promotions, semicolon, eligibility for promotion, semicolon, rights of chief deputy, period." Now, obviously, this particular section, Section 13, speaks to at least 3 different issues. Clearly, one of them has to do with the rights of the chief deputy. And what it says in there is that, except for the chief deputy, no person shall be eligible for promotion from the lower grade to the next higher grade until such person has completed at least 2 years service in the next lower grade. Now, that's just saying that, if you are employed as a deputy and you want to go from patrolman to lieutenant or sergeant or captain or any other increase in rank, you have to meet testing requirements and meet other statutory qualifications before you can be promoted. Now, it goes on to say, any person occupying the office of chief deputy, okay, this is where we get to the third of the 3 issues addressed by Section 13. Any person occupying the office of chief deputy, pursuant to the provisions of Section 2, Article 8 of this chapter, in any such county, on the effective date of this article, and anyone thereafter appointed as chief deputy, shall, except as hereinafter provided, be and shall continue to be entitled to all the rights and benefits of this article. Now, if you are willing to go back and do the historical reading that is urged by counsel for Michael R. Kelly, who until July the 12th had standing to argue the point, you'll find that there was an Attorney General opinion that said, I believe this was 1978, Chauncey Browning was the Attorney General in those days, that if a sheriff has a chief deputy who they've appointed, and the sheriff, under the code, could appoint anybody. They didn't have to even have a background in law enforcement. If the sheriff appointed someone as the chief deputy, and then that person, for whatever reason, was going to step down in rank to another position within the department, they would have to go through all the qualifications and civil service testing, etc., to demonstrate qualification for that position. The sheriff could not simply bring in someone at his will and pleasure, appoint them as the chief, and then for whatever his reason might be, come before the county commission and get the commission to approve the reassignment of that person from chief deputy, say, to sergeant, and then presumably appoint somebody in that fashion. And the Chauncey Browning's office went on to say in that opinion that was cited and argued by Chief Deputy Kelly in this case and embraced by the election court. In that fashion, a sheriff could populate the entire department with deputies who did not meet or never put through the testing process provided by the code. So, that's all the more that old Attorney General opinion had to say. It was not an election case. It was not an issue where the Attorney General was asked whether the prohibition against partisan political candidacy on the part of deputies applied to chief deputy. That was not the issue. That was merely an implication urged bipartisan who at the time had standing. So, the ambiguity and uncertainty which is invoked in the final order entered in this case by the election court does not exist. It was only uncertain under the old version of the statute. That statute was substantially revised, 2007. As we cite in our final brief, our reply brief, as well as in our appeal brief, we reprise the same argument. Legal doctrine is well established to show that the court must presume that the legislature, when they revise a statute, knew what they were doing and intended the revisions that they rendered. The language that is current law found in 714.15 subparagraph A, subparagraph 4 is in the 2007 version of the statute. It very plainly says that you cannot be a deputy in the department and run for public office. And then it goes on to state in a proviso in the very next legislative breath that any deputy who is subject to the Hatch Act likewise may not run for public office.
So you're saying, if I understand you correctly, that the language is sufficiently clear that it's not subject to interpretation by the lower courts?
That is correct, Your Honor. What the election court below did, as evidenced by the language found in the final order entered July the 26th, bear with me just a moment. Beginning at page 722 and continuing on to 723, the election court states correctly that they are to look to the plain meaning of the statute. What they proceeded to do was pose the rhetorical question, was Michael R. Kelly subject to the Civil Service Act at the time that he stood for election on May 8th? Pardon me. The court says that, beginning on page 722, it says, unfortunately, I'm reading in the first paragraph following the caption that says discussion. Unfortunately, neither this nor any other code section provides a specific description of the political restrictions upon a chief deputy. Well, yes, it does. 714.13 clearly says that the chief deputy is subject to the Civil Service Act. And 714.15, subparagraph A4, clearly says that if you're so employed, you can't run for public office in the county, and if you're subject to the Hatch Act, you certainly may not stand for public office. So they're just wrong when they say that there is no specific description of the political restrictions upon the chief deputy. They go on to say that there's no Supreme Court precedent that settles the question. Well, we talked about the Sowards case that interpreted the old version of the statute, and I would submit likely resulted in the substantial revision of the same statute in 2007 to address those very issues. Then they go on to say because there is uncertainty in the law that they're going to look at the legislature's intent regarding these matters. And then they indulge the review of pre-enactment and post-enactment legislative history. And they cite to some documentation that Chief Deputy Kelly's counsel submitted at the trial. He submitted one exhibit, and that exhibit was a mock-up or a draft document of a proposed legislative revision that purported to insert the words "and Chief Deputy Sheriff" in section 714.15. I don't know, but I would dare say if the time and expense were spent on it, we'd probably find that Mr. Hartman, being the legislative activist and lobbyist that he is, may have even had a hand in submitting that proposed language. But my point is that it doesn't matter. It doesn't matter. There's no ambiguity in this statute. The chief deputy is subject to the Civil Service Act. He enjoys all of the protection. The only thing that sets him apart is that he is appointed to his position by the sheriff. But once he's appointed to that position, he's subject to the Civil Service Act. The code says so.
Thank you, sir.
The other elaboration that can be found in the final order appears on 723, where the election court goes on to say that the chief deputy is appointed by the sheriff, which is true. It follows that will and pleasure employees are not afforded civil service protection under Article 14, Chapter 7 of the Code. That's just wrong. That's just wrong. Section 13 says that's wrong. There's no citation to Section 13 of the Civil Service Act. There's no effort made to distinguish that language or to explain why it doesn't apply to this case. None. It's just totally ignored. It hinges its entire reasoning and argument on the fact that the chief deputy is an appointed position. It goes on to conclude that because he's an appointed chief deputy, he's not subject to the Civil Service Act. We know that is unequivocally and without a doubt wrong as a matter of law. Then they go on to cite this old Attorney General interpretation that I've been talking about already. 1976 was when that was decided. And they simply go on to embrace the error that I've been talking about, and they ruled that Chief Deputy Kelly was not subject to the prohibition found in 714-15A4. And since that two-pronged prohibition against his political activity did not apply to him, then there was no error in the certification of the election that was held on May the 8th. The certification that was entered on May the 18th is valid, and our petition was in error and should be denied in all respects, and Chief Deputy Kelly was the newly elected candidate on the Republican ticket for the office of sheriff in Upshur County. Because he subsequently withdrew, that created a vacancy nomination under Chapter 3, and then we go on to bow to the code provisions that call for the recognition by the State Election Commission and the subsequent appointment of a replacement by the County Executive Committee Republican Party. So the court sees that really there are no facts in dispute here. What facts would there be necessary to this decision? There was the election on May the 8th. Everyone agrees. Michael R. Kelly got more votes than the next highest candidate, David D. Taylor. Nobody disagrees with that either. The certification was made on the 18th. That is true. We filed a timely petition to stay the finality of that certification. We prepared for and tried the case on the 18th of July, some 6 days after Michael R. Kelly withdrew from the election, and we lost. We lost why? Because the election court embraced the error of saying that the provisions that disqualify deputy sheriffs from running for public office found in 714-15A4 simply did not apply to Michael R. Kelly because he was an appointed chief deputy. I've demonstrated that that was error. He is subject to the Civil Service Act under Section 13 of the Civil Service Act. The court knows, without my saying it, that statutes are to be read in pari materia, so that all sections apply in a cohesive, coordinated, logical fashion. Section 13 brings Chief Deputy Kelly under the protection of the Civil Service Act at the cost of his also being subject to the disqualification under 714-15A4, both state law as well as the proviso which makes reference to the federal Hatch Act. There's no doubt, there's no dispute that as the Chief Deputy of the county, Chief Deputy Michael R. Kelly was subject to the Hatch Act. He was disqualified for that reason, as well as the very reason that he was a deputy in the department.
Okay, so you'll have the right to close the argument.
Thank you.
Mr. Harmon?
Thank you, Your Honor.
Sir, could you
Oh,
press the
turn it
button
on?
on your mic.
Blue? Yes, okay. Thank you, Your Honor. Maybe we should start on the one and only point on which we agree. I do think that generally this is, the facts are not in dispute, that this is a matter of law for this court to decide. The equivalent in a standard civil case, I suppose, would be cross motions for summary judgment. The facts aren't in dispute, but the law is, Judge. So, lucky you get to decide the whole thing. But we do, it is Mr. Taylor and his counsel's burden today to prove that there was error below. We don't think that there was. We think that the county commission got it right. First off, as it relates to assignments of error, standing. Mr. Kelly certainly has standing. His name is still on the case. He is a respondent. He has a reputation and correction of the record to protect. And that, while accusations as it relates to the Hatch Act, it appears nefarious, as if there's been some sort of wrongdoing, when in fact Mr. Kelly just received a regular paycheck from the Upshur County Commission, as he had always done. So he has a duty and the right to protect that. Additionally, he has a financial interest to protect. He was subject to the assignment of costs in the matter below, depending upon the outcome of that matter, and he certainly had the right to defend against that. So he had sufficient standing in our view, Your Honor, to be there and to be here today to protect those interests. As it relates to the second assignment of error, that the county commission below simply was wrong as it relates to the application of the Civil Service Act in West Virginia. As this court is aware, the chief deputy is exempt from civil service protection. He is a will and pleasure appointee to be fired at the whim of the sheriff. And he is exempt from civil service protections. The guidance in that matter is the very first section of code in the Civil Service Act that specifically exempts the chief deputy. No person except the chief deputy shall be appointed, promoted, reinstated, removed, discharged, suspended, or reduced in rank of pay in any manner or by any means other than those prescribed in this section. It specifically exempts him from the Civil Service Act. Mentions of the chief deputy later, and I believe in section 13 to which counsel refers, is upon the deputy's return to the workforce, that the political patronage of a sheriff, bringing someone as his chief deputy under will and pleasure, once that sheriff either serves his term or loses an election, it doesn't mean the chief deputy that therefore loses employment. He can return to the workforce under his previous rank. That protection relates to his return to the workforce, not his status as the chief deputy. Additionally, and further support, as set forth in the County Commission's order, or Attorney General's opinions clearly defining that and clearly articulating that point of law, as well as the fact that under two successive legislative sessions, there have been amendments, both in 2010 and 2011, attempting to specifically include chief deputy. And
include chief deputies in what capacity?
Well, the fact that they would include them in the section in which he is accused to violate 7-14-15. That
would include him by saying any deputies, including chief deputies.
Yes, sir. That was the proposal in both 2010 and 2011, and that legislation did not pass. I think it's persuasive. I would agree that something that did not occur at the legislature in and of itself is not significant, but the fact that it was necessary for the legislature to consider this amendment and for their effort to specifically include them clearly suggests that there is some ambiguity about whether chief deputies are subject to the Civil Service Act.
As a former member of the legislature, I don't know that all proposed amendments to bills could be justified as being required.
As being necessary?
Necessary for the public interest.
Understood. We think that it is persuasive to suggest that there is ambiguity about whether the Civil Service Act applies to a chief deputy. If there is some ambiguity, and the county commission resolved that ambiguity in a proper fashion, that they can look to other sources for clarity on that.
What about the language in the current statute? Is that not clear enough?
It is clear, Your Honor, but I do think, but clear as to what? And the Sowards case helps clarify that for this court and for the county commission.
But Sowards was decided prior to the change in the law.
But the constitutional principles that it espouses hold true. That whether the Civil Service Act, the act that we're talking about, Civil Service Act, relate to the conditions of employment for Mr. Kelly, not the conditions of the ballot or candidacy. Those are prescribed through the Constitution or through other devices, not through the Civil Service Act. Even if it did apply, which we do not believe it does, even if it did apply, it does not mean that he can be removed from the ballot. It means that he can be removed as a deputy sheriff, or he no longer has the right to that employment. And the Sowards case articulates that constitutional principle that people have the right to become, to be on the ballot, to run for office. They have guarantees. But if...
Doesn't Sowards say unless they're statutorily disqualified?
That's correct. That's correct. We do not think that
you don't think that statute is statutorily disqualified?
No, I think it disqualifies him from serving as a chief deputy. He can remain on the ballot, but he can't be a chief deputy while he does it. And that's exactly what the Hatch Act says. The Hatch Act, the U.S. office...
Couldn't be any deputy at all, right? Instead of just chief deputy.
Couldn't be our argument is he couldn't be a deputy, but he can be a chief deputy because that section does not apply to him. And chief deputies have been running for the position of sheriff in every county in West Virginia since I'm 44 years old almost, since I can remember it, since I've been paying attention. That they do have the entitlement to do that. They've historically done it. 31 deputy sheriffs in this election cycle alone are in a similar position. But the chief deputy is exempt from that position, and that has been the interpretation, and that has been the practice in West Virginia for years. So we don't think that they got that wrong. But even if they did, it doesn't mean that he can be removed from the ballot. While the statute has changed, the constitutional principles have not. And Sowards clearly articulates the right for a citizen to be on the ballot, not necessarily the right for them to hold the position of a deputy. And we think that that's clearly set forth. The other assignments of error as it relates to the application of West Virginia Code Section 3519, how to fill a vacancy. We think that is absolutely clear. We think that that the State Election Commission and the Republican Executive Committee followed the appropriate procedure and the appropriate law under the circumstances. That when a vacancy occurs, this is the procedure that's done. It articulates in 3519A6, if a vacancy occurs by the withdrawal of candidacy, there's a particular procedure. Even if you don't believe that a withdrawal effectively occurred, if you believe that Mr. Crook's argument that he was disqualified or that he was ineligible to even be on the ballot, there's a procedure for that. It doesn't mean that the second place finisher gets it. There's a procedure for disqualification set forth in 3519A subsection 4. If you buy Mr. Crook's argument that Mr. Kelly had no right to be on the ballot, he would be disqualified. And under that situation, there's a procedure for that as well. Mr. Crook's analogized in the hearing below and analogized again here today, Judge, that what he has done is, as Mr. Kelly scored a touchdown, he threw a red flag and asked for everybody to hold on and review it. And a couple of things can happen. Either Mr. Kelly gets the touchdown or he doesn't get the touchdown. But under no circumstances in the analogy do you give the other team a touchdown. That's not how it works. And this code section sets forth that clearly. He's not entitled to the relief that he seeks. We think that the court below, Judge, got it right. We do. And the assignments of error as pled, they have not met their burden, and we think that the ruling below should be affirmed.
Sorry, and your name again, please?
Tim Stranko, Your Honor. I'm representing the County Commission, and I'm proud to do so this morning because, and I thank council for his compliments with regard to the proceeding. The Commission was and continues to be studiously neutral, perhaps indifference, another word, as to which candidate is on the Republican, nominated on the Republican ballot for sheriff. What the Commission is conversely studiously concerned with is the voice of the people of Upshur County. There's no question, Your Honor, that this was a free and fair election. There's no allegation of any kind of misconduct with regard to polling, with regard to counting the ballots, and with regard to the certification. No question whatsoever. The people of Upshur County have spoken on a 2-to-1 margin who they want to be their sheriff. Now, the conundrum is this, Your Honor, and let me address a few points in turn, because there's a lot of imprecision going on here. Council did not make it clear to this court. Let me emphasize, there were 3 candidates. And it is simply impossible, and contrary to the specific Supreme Court precedent, for this court or anybody to sit and disqualify the first vote getter, and then say the second vote getter is therefore the winner. It is illogical, Your Honor. If there was a 2-person race between the second and the third place vote getters, we don't know who would win that race. So we are taking the prerogative of the people of Upshur County away from them by this proposed relief that the council is asking for.
Council, just correct me if I'm wrong, but from where I'm sitting, it looks like the prerogative of the voters is taken away either way. Because if I accept the arguments of Mr. Crooks and logically follow that to its conclusion, I will be putting the mantle on the second vote getter, which, as you suggest, disenfranchises those people who apparently were in the majority that voted for Officer Kelly.
Yes, sir.
But you don't. But as I understand the situation, Officer Kelly is subject to the Hatch Act and has opted to, instead of resign as deputy sheriff, to withdraw from the race. So you have a situation in which another person has been appointed by a small committee and not by the voters of Upshur County. So it sounds to me like the voters kind of got the shaft either way.
Excellent points, Your Honor. Let me address them in turn. And the part of the imprecision that I talk about is the Hatch Act. If you endorse counsel's petitioner's argument here, we are allowing an opinion, an advisory opinion, his words, advisory opinion of an attorney working at the Office of Special Counsel to disenfranchise the vote of the people of Upshur County, disenfranchise Chief Deputy's right to run for office as a citizen of West Virginia. There was no due process. There was no adjudication. You know, Judge, I think all my opinions are right. But the fact is, we have an advisory opinion. An attorney sitting in an office in Washington, D.C. decides that Chief Deputy is subject to the Hatch Act. There's no judicial review. There's no due process. And we're talking about a fundamental constitutional right that we are taking an advisory opinion and saying, well, therefore, we conclude that the Chief Deputy is subject to the Hatch Act.
But it's the Chief Deputy who decided for himself when he withdrew.
Yes, sir.
He accepted their opinion. It wasn't the County Commission of Upshur County that took that away from him. He decided that on the basis of the letter from the Office of Special Counsel, is it? That he needed to withdraw.
Yes, sir. I respectfully disagree with that interpretation, Your Honor. Whatever the Chief Deputy's motivations were for withdrawing, whatever they might have been, there's nothing on the record that says that the Chief Deputy endorses the Office of Special Counsel's opinion or agrees with the Office of Special Counsel's opinion. In fact, at hearing, the reasons the Commission received for withdrawal were entirely personal and not an endorsement of the Office of Special Counsel's advisory opinion. And even if he did endorse the Office of Special Counsel's advisory opinion, I still contend that this court cannot take an advisory opinion from an attorney and disenfranchise both the Chief Deputy and the people of Upshur County. I think that is a fundamental problem with the petitioner's argument. And to say that the Office of Special Counsel has exclusive jurisdiction, no. A court has jurisdiction. There is a federal court that would hear if Chief Deputy chose to contest that advisory opinion or to continue on the path that he had started on, he would be entitled to due process and not be rejected by an advisory opinion of Office of Special Counsel. It's simply elevating an advisory opinion to a level that is inconsistent with our Constitution. We cannot disenfranchise this man because a lawyer wrote an opinion. Now, he chose to withdraw from the election. Whatever his reasons were, the County Commission doesn't care. The County Commission's issue was, is he disqualified by the Hatch Act? There was nothing in the record that allowed the County Commission to make that conclusion. There was, yes, an advisory opinion from an attorney working at the Office of Special Counsel, which we respect and respectfully reviewed, but that is not a judicial finding or any due process that was afforded to the Chief Deputy as he was a candidate for office. Now, I think it's also important to note that Mr. Crooks has said we're challenging the result of the election. That's not exactly right. The result, again, the result of the election is not an issue. It is a fact that the Chief Deputy won 2-1, won every precinct in the county. And now, based on an attorney's advisory opinion from the Office of Special Counsel, we look to disenfranchise both the Chief Deputy and the people of Upshur County. And the relief that he's seeking is to somehow decide that if Chief Deputy wasn't on the ballot, that the second place finisher would win. And again, that's illogical and contrary to West Virginia law. The Civil Service. Your Honor, it is the Commission's opinion that this statute's a mess. We parse the statute the best we can. We try to understand the legislative intent. We try to understand what the law requires us to do and what the law affords with regard to protection and duties. However, in parsing those statutes, what the Commission had in mind and what this Court should have in mind, first and foremost, is not to disenfranchise the voters of Upshur County. Now, faced with the conundrum that the Chief Deputy withdrew before the hearing, the County Commission's mission, how do we get this as close as we can possibly get it to a free and fair democratic election? In other words, do we, by fiat, say that this man, the petitioner, is now the Republican candidate? No. What we try to do is get it as close to a free and fair election as we can get it. The Republican Executive Committee is an elected body charged with the duty, both statutorily and within their own party, charged with the duty of administering the Republican Party actions in Upshur County. So, faced with the conundrum of do we use an attorney's advisory opinion and disenfranchise people of Upshur County, or do we give the Republican Executive Committee an opportunity, as by code, to sort through this and select a candidate? The Commission chose to follow the code with regard to a withdrawn candidate and the Executive Committee's prerogative and power to appoint a candidate. And the Court will note that Mr. Taylor was again a candidate in front of the Republican Executive Committee, and again was not successful in that candidacy. Your Honor, this Court should be focused on the constitutional principle and the power of a free and fair election. And that is what the Commission's focus was as well. We believe that the law is clear. The Hatch Act does not apply here, absent. We're not going to disenfranchise somebody or take away a constitutional right absent of some due process. Using an advisory letter from an Attorney General, from an attorney, is simply beyond the pale. And secondly, the Civil Service Act. If he's serving it as will and pleasure, it follows that he is not protected under the Civil Service Program. And if the Court reviews the statute, you'll see that there are plenty of ways to interpret one way or the other, and the Commission came down on the side of the interpretation described by Mr. Herman.
Wasn't the county court in itself relying upon an Attorney General's opinion in making its decision.
The commission was looking at that Attorney General's opinion, trying to understand what a chief deputy is. Is a chief deputy something apart from a deputy? And they looked at everything they could look at to make that decision.
And that apparently was 1975 Attorney
Yes,
General's opinion, which of course predated the current statute
Certainly wrong.
by a number of years.
A number of years, Your Honor, but this court will note that a chief deputy, a description of that position is not clearly enumerated in the statute. The question of whether
Is
it's not
deputy defined in, is deputy sheriff defined in the statute?
a deputy sheriff is defined in the statute. A chief deputy is wholly apart from that. And because they're
Is
serving
the
in one
definition
place.
of a deputy sheriff in the statute encompass what we call chief deputy sheriff?
It couldn't, Your Honor, because a deputy does not serve at the will and pleasure of the sheriff. A chief deputy serves at the will and pleasure of the sheriff, so fundamentally, they're not covered under the civil service statute. Now, this county civil service board may have chosen to offer some protections. Whether or not that's right is not before this court. The fact is that a will and pleasure employee is, by definition, not protected under the Civil Service Act. If the chief deputy is serving and was prior qualified as a deputy, he resigns as chief deputy, he has no right to bump into a deputy's position if he's not prior qualified as a deputy. The statute is a mess. You can interpret it either way. What we're asking this court to do is interpret it to enfranchise both the people of Upshur County and the chief deputy's right to run for sheriff.
So it's your position that the Hatch Act would not have prohibited Deputy Kelly from staying on the ballot?
No, sir. My position is that there is nothing in front of the commission conclusively ruling that the Hatch Act applies to the chief deputy. We have an opinion from the Office of Special Counsel, an advisory opinion in the words of Mr. Phillips. That is not enough to disenfranchise.
So what about so you think the county commission didn't have the obligation to consider that portion of code 714-15A4 that contained proviso to the effect that anyone in violation of the Hatch Act was ineligible to run for any office. And you don't think apparently they didn't address that because they took the position they did not have any jurisdiction to make a Hatch Act determination.
Yes, sir. There was no...
The code, the West Virginia Code, kind of made it their obligation, didn't it, when it contained that proviso?
Yes, sir. And we had a hearing. And the petitioner was free to put in record anything that would be conclusive.
Well, they claimed they did. They claimed they put in a lot of information that showed that the department received federal funding and thus was clearly subject to the Hatch Act. They claimed they did. Are you saying they didn't?
No, and we will admit that the department receives federal funding, and we would also...
It sounds like the county court just decided they weren't going to touch the Hatch Act issue.
We took evidence on the Hatch Act, Your Honor, and that was an advisory opinion from an attorney in the Office of Special Counsel. And the commission...
You're telling me on one hand that you accepted the opinion, on the other hand you're saying you didn't.
No, Your Honor. I'm saying that it is a matter of record that we have an advisory opinion from the Office of Special Counsel that says that he's subject to the Hatch Act. The commission looked at that and said, is that enough to disenfranchise the people of Upshur County and the chief deputy as a candidate? No. An advisory opinion from an attorney does not rise to the level of taking a constitutional right away. This is a fundamental right.
Well, how does that tie into West Virginia law? In that code section that has the proviso that says basically if a person is prohibited by the Hatch Act, they are ineligible under West Virginia law.
Yes, sir.
And then you go into the Cyrus decision that says, of course you do not allow people to stay on the ballot who are statutorily disqualified.
Yes, sir.
Now, I don't understand how you go around that.
Well, Your Honor, if we had it in the record what the commission would consider a due process hearing or some adjudication from a neutral judge that the chief deputy is subject to the Hatch Act. We don't have that. We don't have that in the record. We cannot act to disenfranchise somebody or to apply West Virginia law based on an opinion from the Office of Special Counsel. That does not rise to a judicial finding.
But did they make the finding, they could have avoided that if they made the finding that he was not subject to the Hatch Act, and why? And did they do that?
No.
They just kind of ignored it. Is that what you're
I'm sorry, I thought you were asking me
Did
about the
they
Office
make
of
a
Special
specific finding in their decision that the deputy Kelly was not subject to the Hatch Act?
No.
So it's just kind of, it sounds to me like they kind of ignored the proviso in West Virginia law that provides for a statutory disqualification.
Judge, there was nothing in the record, again, there was nothing in the record conclusive
But the issue was raised.
The question was raised but not resolved.
They didn't decide it.
Counsel, there was nothing in the record to decide, Your Honor. All we have was an advisory opinion. How can we use that to say that he is subject to the Hatch Act? Counsel had ample opportunity to give us other evidence or to find some more persuasive authority, but now the commission is faced with an advisory opinion. Use that to apply West Virginia law to disenfranchise the voters, and the commission decided not to do that.
But at the time they decided to do that, he had already withdrawn.
Yes, sir.
So those voters were in effect disenfranchised at the time. So I don't get the argument that they were acting not to disenfranchise the voters when by his own actions he disenfranchised the people that voted for him by withdrawing and leaving it up to a political body to select another person that the voters hadn't chosen.
The voters hadn't chosen the petitioner either, Your Honor.
Well, I'm not suggesting, well, he came in second, I guess, but I don't get this argument about the disenfranchisement standing up for the right of the vote.
Yes, sir.
When they knew that the candidate whose disqualification was being sought had already taken himself out of the race and disenfranchised his voters.
Judge, the people that voted for the chief deputy made that vote not knowing that there would be some statutory flaw here or that we would find some reason to disenfranchise people, if I could finish, Your Honor. So when he withdrew, that was after the vote was cast. So yes, he disenfranchised those voters. The county commission didn't and would not.
And I agree with you. The point I'm making is if the county is hanging its hat on this notion of not disenfranchising the voters, that seems to be a ludicrous argument if they knew at the time that they made this decision that he had already disenfranchised his voters by withdrawing.
No, Your Honor. You said hanging the hat. I tried to give this court the county commission's motivation, which is, again, to protect the franchise, the constitutional rights. That's their motivation. What they're hanging their hat on is that we have no evidence in the record, conclusive evidence, that the chief deputy is subject to the Hatch Act, and we've got a body of law that the legislature has dumped down here that is ambiguous as to whether the chief deputy is covered under the civil service provisions. So with that ambiguity and with that weak evidence or suggestion only that he's subject to the Hatch Act, the county commission did not have enough to disenfranchise the voters, or stated differently, did not have enough to endorse the appeal.
Thank you, sir.
Thank you.
Mr. Brooks, you have the right to close the argument.
Thank you, Your Honor. First point I would like to make is that Mr. Stranko omits mention of several pertinent matters that were addressed below. Number one, he omits mention of the fact that Chief Deputy Kelly requested an opinion from the Office of Special Counsel. Why do you do that? The other thing that I would point out, and for this I would refer to exhibit number 1 below, which is a copy of the letter dated dated June 21, 2012, from the Office of Special Counsel. Now, the Office of Special Counsel explains very carefully that they are the body that's authorized to investigate violations of the Hatch Act and to issue advisory opinions. That's federal code. They are authorized. They're not acting outside their jurisdiction to consider the information submitted to them and to issue advisory opinions. So to argue that the Constitution is being trampled upon because Chief Deputy Kelly requested an opinion and got it from a body that was authorized by statute to do that very thing is simply, contradicted clearly by the express provisions of federal law. So that's number one. The suggestion that the Office of Special Counsel conducted some in absentia trial behind a closed door someplace and convicted Chief Deputy Kelly of violating the Hatch Act simply is not true. He asked for an opinion, he got it. Likewise, my client submitted a complaint and asked for an opinion. That's what the parties to this election dispute got. An opinion that was authorized by federal statute from the sole body that had the power to give it. Second, this is a connected point. At page 2 of the letter from the Office of Special Counsel, they explain that Chief Deputy Kelly's failure to come into compliance with the Act, the Hatch Act, could result in disciplinary action charges being brought against him before the Merit Systems Protection Board. So, the Office of Special Counsel serves not only as an investigator and someone who provides opinions to guide people, but they also have the power to act as prosecutor. And this is what they were putting Chief Deputy Kelly on notice of. Recall, I pointed out that the letter afforded Chief Deputy Kelly an option, an ultimatum. Either change jobs such that he's not subject to the Federal Hatch Act and carry on as a candidate if you care to, or withdraw from the election so that you won't be violating the Hatch Act. Keep the job you got. He elected for the latter, and he did so on the very last day allowed to him by the terms of the letter from the Office of Special Counsel. Now, the Office of Special Counsel went through in their letter and detailed numerous instances where federal funds flow into the Office of Sheriff in Upshur County. The counsel for the County Commission just acknowledged right here, right now, that there's no question federal funds flow into that department. The exhibits that are in the record demonstrate that the job description for Chief Deputy calls for him to supervise and provide administrative services across the entire department. In fact, the statute, the code says that the Chief Deputy shall act as the sheriff in the absence of the sheriff. So if the sheriff is on vacation in South Carolina, guess who's the acting sheriff for Upshur County? Chief Deputy. I want to make my comments responsive to the arguments that the court heard in opposition to our presentation. The argument was made by counsel for the County Commission that my client is not challenging the primary election. Well, that's just false. We are challenging the results of the primary election. That's why we invoked the provisions found in Chapter 3, Article 7, Section 6, and Section 7. Mr. Stranko says that there's no provision in West Virginia law that would allow the County Commission sitting as an election court to recognize my client as the winner of the election. Well, that's just not true. the West Virginia Code specifically says, and this is what we invoked in our petition, there was no mistake about the jurisdiction we invoked before the county commission. In fact, the final order recites that they were exercising jurisdiction under 3-7-6, which was enacted in 2002. Wasn't enacted, it was revised. It existed previously, but it was revised in 2002. It says very plainly in the statute, 3-7-6, in all cases of contested elections, the county commission shall be the judge of the election, qualifications and returns of their own members and of all county and district officers. It goes on in the very next paragraph to say, any person intending to contest the election of another to a county or district office, including judge of any court or any office that shall thereafter be created, shall, there's that mandatory term that we in the law are so familiar with, it's a non-discretionary command, shall, within 10 days after the result of the election is certified, in this instance it was certified May the 18th, give the contestee, that's Mr. Kelly in this instance, notice in writing of such intention and a list of the votes he will dispute. Well, that's not the nature of our contest here. We're not disputing individual ballots. With the objections to each and the voters rejected for which he will contend. If the contestant objects to the legality of the election, which we're not contesting the legality of the election, it was held at the appropriate time and in the appropriate way, or the qualification of the person returned as elected, there it is. That's what we are contesting. Qualifications of the person returned as elected, the notice shall set forth the facts on which that objection is founded. We did all that in our petition. We argued the points of law that the court is focusing on.
I'm sorry to throw you off your pace, but I have a question.
Yes.
What is the definition of a deputy sheriff under Chapter 7, Article 14? How is a deputy sheriff defined for purposes of that statute?
Your Honor, I would submit to you that the definition that you're looking for is found in the exhibits we submitted. It is going to be found in Chapter 7 of the Code. All right, under tab 3 of our exhibits.
I don't think I have your exhibits.
Oh, I'm sorry. I thought the clerk would have the court file available.
Well, the file's here, and maybe the exhibits.
Maybe they've been taken apart in order to bind them into the...
Well, it looks to me like the record in this case was transferred over from the clerk of the county commissioner's office.
Yes, sir.
Because it's it's sort of on the long paper, you know what I mean?
Yes, sir.
And
Well,
it's a little bit difficult to negotiate this thing.
yeah.
I think I actually do have it.
And under tab 3, if you can identify our exhibits by that fashion, you'll find where my client sent a request for information, Freedom of Information Act request, to be more precise. And this was directed to the Upshur County Sheriff's Office. And his second inquiry was for job descriptions of the positions of Chief Deputy, Lieutenant, Sergeant, Corporal. The response contained a definition not only for those positions, but that of Deputy Sheriff as well. And that runs for several pages naturally.
Are those definitions statutory definitions? If you're not, I'm afraid they don't help you.
Yes, I understand. What this job description says is that that this statement of job description was prepared as recommended by the West Virginia Civil Service Commission, which of course would be empowered by the very same chapter of the code that the court is asking about, Chapter 7.
Rulemaking.
Yes. And I would also hasten to point out that this set of job descriptions promulgated under the authority of the State Civil Service Commission includes a definition of chief deputy. It's the last position that's described.
Definition or description?
Well, description, I'm sorry, I used the word definition, probably should not have. It's a job description.
I'm looking for statutory definitions if there are any.
There are. I wish I had my, you can only carry so much. I didn't carry my volume of Chapter 7 of the code in here with me. I'm sure we're going to find that. Probably in 7-1-1.
Bear with me a moment.
Certainly. I'm sorry, I don't have that ready for you. I know that if it won't throw you, Your Honor, I might be able to help you here. Chapter 7, Article 14, Section 1 talks about appointments and promotions of deputy sheriffs.
I'm looking now at 7:14-2.
2, yes, it's the definitions
Purpose of this
provision.
article, deputy sheriffs or deputies shall mean persons appointed by a sheriff as his deputies, whose primary duties as such deputies are within the scope of active general law enforcement, and as such are authorized to carry deadly weapons, patrol the highways, perform police functions, make arrests, or safeguard prisoners. This definition shall not be construed to include any person or persons whose sole duty shall be the service of civil process and subpoenas is provided, and et cetera, et cetera. Now you notice deputy sheriffs or deputies shall mean persons appointed by a sheriff.
Chief deputies are certainly appointed.
I was thinking the same thing. Carry on.
Primary duties are such duties as deputies are within the scope of active general law enforcement. Certainly the chief deputy is empowered to do all those things. The only thing they exclude in this definition are process servers and jailers. I don't know if they exempt bailiffs. But at any rate, clearly by virtue of 714-2, which I do have a photocopy of, I don't necessarily have the code volume, but Your Honor has seen it for yourself. The position of deputy sheriff, as defined under the Civil Service Act, certainly takes in the position of chief deputy. And again, I would just reiterate that Section 13 of that Act, by its very title, makes sure that the rights of chief deputy are protected for all purposes.
But the fact that they put that in there, doesn't that suggest that they were thinking of chief deputies as somewhat different political creatures?
A little bit, and a careful reading of the code demonstrate that the distinction that is preserved throughout that act is that the chief deputy is someone who can be appointed at the will and pleasure of the sheriff. All right? And in fact, as I said a little earlier, if we indulge the pursuit of history and go back and look at the Attorney General opinion rendered by Chauncey Browning, as well as the Sowers case, what we see in there, specifically in respect to Chauncey Browning's opinion, the chief deputy, because he is appointed, or she is appointed, does not necessarily meet the same standards for qualification as a deputy as would those under the chief deputy. And so if the sheriff goes before the county commission in their county and asks that the chief deputy be reassigned as a subordinate officer, according to the Attorney General, that person, because they were appointed by the sheriff, have to demonstrate that they are otherwise qualified to serve in a subordinate position, such as lieutenant or captain or sergeant, what have you. That person might meet those qualifications. You could have somebody who maybe was employed as a deputy sheriff, maybe as a lieutenant or a captain. They retired from that position, a new sheriff gets elected. The new sheriff wants to appoint that person as their chief, and in the course of time, they want to reassign them as a captain. Well, by virtue of their prior work history and qualifications, they may very well meet all those requirements. And I would submit that, according to Chauncey Browning's opinion, that person, could be approved.
Mr. Brooks, if I understood Mr. Hartman correctly, he's suggesting that chief deputy sheriffs have been allowed to run for the sheriff's position since time immemorial, and that there are probably numbers of them on the ballots in the various counties around the state as we speak, whose condition as being available to the voters to vote for may be adversely affected if this court buys your argument.
Yes, Your Honor. I would have 2 or 3 points to make in response to that suggestion. Number one, that's not in the record. That's not part of the record that's being presented here for review. So that's extrajudicial.
I don't know how we could ever get it in the record.
I don't either.
Accurately, because it may be totally baloney, but it does seem to make sense if he's correct that there is a general perception that the chief deputies can always run for this.
Right. I have made my point, and the court, I'm satisfied the court understands that it is extrajudicial, number one. Number two, it's probably true. There probably are a great many instances where the state code provision that we cite has been violated repeatedly. What Mr. Hartman did not offer to this court was any evidence to suggest that anybody else anywhere in the state of West Virginia in this similar situation has gone to court and obtained an appropriate judicial declaration stating that they're entitled to run despite their position as chief deputy in the sheriff's department. All he has done is posited the fact that this has been done and is currently being done in many other places in the state without judicial sanction or permission. All he has done is point out to the court that this case is momentous. There was a time when people of color in this country weren't recognized as citizens. There was a time when many civil rights violations were the law of the land. Things that now are regarded as a violation of law and are outlawed and are remediable in court. I submit that this election issue that's currently before the court may not claim to the same moral high ground that the civil rights history of our country claims to, but it does have dignity, it does have importance for the very reasons that Mr. Stranko has repeatedly urged to this court. We're talking here about the franchise. We're talking about the respect for elections. He says, Mr. Stranko says that there's no provision in West Virginia law that would allow the county commission sitting as an election court to recognize the disqualification of the highest vote getter and the recognition of the second place candidate as the true winner. He's wrong. We invoke 3-7-6 as well as 3-7-7. And it says very plainly in Chapter 3, Article 7, Section 7, that at the final trial of the contest, which we had on July 18th, the court shall, there's that mandatory term again, declare the true result of such election. The election court had the mandatory, non-delegable duty. They can't punt it to the state election commission. They can't hand it off to the local county County Executive Committee, they have the duty to declare the true result of the election and cause the same to be entered on the records of the court. That's what we asked them to do. What we asked them to do was very simple, was to recognize that Chief Deputy Kelly, by virtue of his employment status, was disqualified and ineligible to be on the ballot May the 8th, 2012, and to declare that my client, who after all, my client, there's no dispute about this, of the two remaining candidates who were eligible, there's never been any question about my client's eligibility, ever. Anyway, the two candidates who were eligible to be on that ballot, as between them, my client clearly got the greater number of votes. Now, if Chief Deputy Kelly disenfranchised those who voted for him by putting his name in contention for an election when he was ineligible under law, that comes back to rest with him. Fact is, my client was eligible, and he was properly on that ballot, and he got more votes than any other candidate who was legally eligible to be on that ballot. There's nothing in West Virginia law that prohibited the election court from rendering the relief that we sought. In fact, it is expressly provided for here. They had the duty. They could not shirk it, try as they have, to declare what the true result of the election was. What could that mean if it doesn't mean recognizing the candidate who obtained more votes than any other eligible candidate as the winner? Obviously the main focus of Mr. Stranko's argument from a neutral election court below was that the election court could not base its decision on an advisory opinion from the Office of Special Counsel. I will not repeat what I've already pointed out to the court, which is that the OSC was statutorily empowered to provide opinions, number one. Number two, he did not at any time address the record that we made with these other documents that show all this money flowing into the county, as well as the responsibilities of the chief deputy to supervise all these programs that are federally funded. You know, these are the very same documents and facts that the Office of Special Counsel was referring to in that advisory opinion letter of June the 21st. Mr. Stranko kind of pled no contest when confronted by the court as to what the state of the record on that point really was. Third thing that I argued in my closing argument, which went unrebutted on this point, is that we had judicial admissions. Look at the response that was filed to our petition. It's admitted. In fact, like I said before, the argument was attempted on behalf of Chief Deputy Kelly to plead a confession and avoidance, as the old common law term would have it. He admitted that he violated the Hatch Act, but he argued that it was unintentional. And for that position, he tried to invoke the Sowers decision, which obviously I can tell by your questions the court's very familiar with.
Well, did the county court have the legal responsibility to make a decision as to whether or not the Hatch Act had been violated?
No.
It did not?
No. It merely had to determine whether Chief Deputy Kelly was subject to the Hatch Act. That's all West Virginia Code says.
And they failed to address that? Is that what you're saying?
Right. They ran from it. They acted as though a finding on that point was something that they had no authority to do. A review of the final order will demonstrate that they equated a finding on that particular point. They equated that with a judgment on whether Chief Deputy Kelly actually violated the Hatch Act. And this is something that we repeatedly said during the trial we were not calling upon the county election court to do. In fact, at the very outset of the proceedings, and I will repeat this, they came to the wrong decision, but the the decorum and dignity of the process, was very appropriate. At the commencement of the trial, the president of the election court announced that the election court would not pass judgment on whether the Hatch Act had been violated. I raised no objection to that position articulated by the president of the election court. I didn't need to prove that Chief Deputy Kelly violated the Hatch Act. All I need to demonstrate is that he was subject to the Hatch Act. That's all the state code says in the proviso contained in 7-14-15 subpart A4. In that proviso provision, it says if you are subject to the Hatch Act, you may not stand for election. That's all we had to show. And we did show it. And we didn't rely solely on the opinion rendered by the Office of Special Counsel, which, by the way, for the third time I will say, because it merits it, was statutorily empowered to render opinions on the issue. And in fact, they were solicited for their opinion. I think those are all the points I have to respond to Mr. Stranko. With respect to Mr. Hartman, he took another run at arguing the provisions of Chapter 3, Article 5, Section 19, which is the statute that deals with vacancies that arise for different reasons. It's true, 3.519 subpart A, subpart 6 says that it applies to situations of withdrawal. And we did have a withdrawal here. And had there not been a timely challenge to the certification of the primary election, this statute would have applied. But that's what they want to, either ignore or gloss over, is the fact that there was a timely challenge to the election filed on May the 25th. And under Section 3-7-7, it was the county commission sitting as the election court that had the duty to try the contest and shall declare the true result of the election. Now, that's what they can't reconcile to their argument. They want to say that Kelly was the appropriately elected candidate. He withdrew, therefore 3.519 subpart A6 applies. Well, they'd be right except for the fact that they're wrong. And they're wrong because of that timely filed election challenge petition that we filed. That final certification that was entered on May the 18th is subject to vacation and amendment first by the election court on the trial below, and now on this appeal by right that Your Honor is hearing at the present time. There is also a provision, 3.519A4, that talks about vacancy by disqualification. And there are instances where someone can be elected in a primary, be on the ballot unopposed. There's no, this happens a lot in West Virginia. How many times can we find examples where someone wins a primary election on, say, the Democrat side, that's the predominant party at this point in history, and there's not even a Republican candidate against them. So to win the primary is to win the general by default. In those instances where there's been no timely challenge to the primary election process, that person is the candidate. And if they are shown to be disqualified after they've won the primary, it could be any number of things that could demonstrate their disqualification that somebody might bring to the State Election Commission. Then there would be that person, if that person were held to be disqualified, unable to complete the election, or perhaps say they die, or whatever reason they become ill, then a vacancy occurs, and then this provision of the code would apply. But it simply just does not apply to this case because we filed a competent, timely election challenge to the May 8th primary process, the result. And of course, we don't challenge ballots. We're not challenging the manner in which the election was conducted. We were simply focusing our election challenge on the qualifications of Michael R. Kelly to be on the ballot at all. Yes, let me reiterate briefly. This is a momentous case. There was a representative in attendance at the trial from the State Election Commission. I spoke to him after the case was rested and submitted for decision.
Are we going to horse the record again?
No, we won't.
Mr. Hartman did.
I merely seek to endorse the concept that the electoral process in West Virginia stands to be impacted by the consequence of the decision in this case. The fact that other counties may be ignoring legal provisions and violating the law without objection, is no defense, no excuse. If the law has been disrespected and is currently being disrespected in other circuits, then in the time-honored tradition of the law, this court has the privilege of setting a precedent that could serve to bring West Virginia's various counties into compliance with the law. That's all. I think the court, I wasn't aware that you had served in the legislature, but your point was most appropriate. Amendments have to be shown to be in the public interest. We don't know.
Well, my point was that, in my experience, there are many things introduced in the form of bills in the legislature that don't necessarily serve an academic goal of improving the clarity of the law.
Absolutely. There are any number of reasons why the amendments that Mr. Hartman spoke to may have been offered, and an equal number, maybe greater, reasons why it never went anywhere. Fact is, we've got the statute that applies to this case, and it's clear enough. I mean, Mr. Stranko assails it as being a hash job, but I have not had any difficulty following it, and I'm satisfied that from the questions the court has asked that it's clear, the issue is clearly understood. I don't know. Let's see. Mr. Hartman said that his client has standing. Well, he does not. He says that he is protecting his good name. Michael R. Kelly's name has nothing to do with the issue that remains for decision in this case by way of our appeal.
Well, you're asking for call sanction.
We have, but you know something, Your Honor, it was pointed out to me by Mr. Stranko that the provisions in 3-7 state that under this particular statute, my client is at risk of being assessed costs, but he cannot recover, and he cannot recover his attorney fees. So there is no risk of personal judgment against.
He's a named party.
Well, he was named party because he had standing at the time. Before he withdrew, up until the time he withdrew his name as a candidate, he was holding himself forth as the duly elected primary winner.
But there was never a motion made and accepted by the county commission that would have changed the name of the respondent.
Oh, there was. It didn't. I didn't ask for a change in the name of the respondent. That wasn't part of the motion, but it wasn't even necessary. I mean,
When had the county executive committee acted to fill what they thought was a vacancy?
When did they do so?
Did they do that before or after this case was decided at the county commission level?
It was. I cannot be precise on the date, but I am confident that research will show that the decision to appoint David Kaufman was made by the county executive committee after the decision was rendered on July the 26th by the county commission. I don't know if they were presuming that we would not file a timely appeal. I don't know what their thinking on that might have been, but obviously, the court system has jurisdiction over the dispute. The court below had the unequivocal duty to declare the true result of the election. They tried to do it. We've brought an appeal by right to this court for review. It's agreed among the three of us that there really are no factual issues in dispute, and it all comes down to an application of the law. And that application of law will declare whether Chief Deputy Michael R. Kelly, at the time he applied for and stood as a candidate on May the 8th, was subject to the Hatch Act. He was. Was he otherwise barred from standing as a candidate in the county because of his employment status in the Sheriff's Department by virtue of 7-14-15A4? He was. So there are two independent but each equally effective disqualification provisions in the state code that we have invoked. They've tried to avoid it. They've tried to argue around it. They've admitted violation of the Hatch Act that said it was unintentional. That's old law anyway. That's not an issue here. They were confronted by the Office of Special Counsel, which has the express authority to investigate, prosecute, and render advisory opinions on the Hatch Act. And they were confronted by an ultimatum, given a deadline, which they got extended by a week, and then they acted on that ultimatum on the very last day. So it's all very clear that he was in fact subject to the Civil Service Act. The Civil Service Act is the article that contains the disqualification provisions. Those apply. We've demonstrated in both cases. And in respect to the Hatch Act part of it, we've demonstrated it 3 different ways.
Thank you.
Thank you.
Your Honor, if I may, there was a point raised by the court and by Mr. Crooks that I wanted to address. 714.
Is there any objection to the gentleman reopening argument?
Well, it is irregular. Depending on what it is he has to offer, I would only have a chance to respond to it.
That, if I'm going to allow it, I would allow that.
Thank you.
Mr. Hartman, any problem with this?
No, sir.
I would ask the court simply to note that 714.2, which we have read as into the record as the description of a deputy, a definition of the deputy, includes general law enforcement duties. Nowhere in that description does it include supervising federal grants, supervising other officers. The petitioner simply can't have it both ways, Your Honor. I think this is clear that a deputy and a chief deputy are 2 very different things. And I would add and ask the court to take note that, as Mr. Crooks offered into evidence, there are job descriptions, different job descriptions for a deputy and a chief deputy. So, thank you.
Okay.
My rebuttal to that is to point out that the section Your Honor cited does apply. The chief deputy has all the authority of a deputy, plus he has the administrative and supervisory authority of the chief deputy. After all, what is his title? Chief deputy. And the description that's in the record was promulgated in accordance with the State Civil Service Commission, and it provides that the chief deputy, in addition to being a deputy, is in a position of acting for the sheriff in his absence and to act in supervisory and administrative capacities. To suggest that Section 2's broad definition of general police duties somehow sets chief deputies separate and apart from that is an incredulous argument that has no basis in the text of the law.
All right. So do you have a couple of these little, like those little small sheets of paper? Thanks. Bear with me a moment, counsel. Gentlemen, thank you for your argument. It's been excellent. And it's helpful. I must tell you now that if I had a preference, I would take this matter under advisement and employ services of a law clerk, which I don't have anymore now that I'm senior stylist. Although there are one or two law clerks that have been made available to the senior status judges, but that usually requires you to make reservations in advance, if you know what I mean. In other words, because of the importance of this case, I would like to study it at length and render a very considered opinion. That's what I would like to do. But if I linger, you may end up with a very nicely drawn out, well-reasoned, and even lengthy opinion, but I'm not sure it will help anybody in the context of this case. I need to decide this case quickly. So any party aggrieved by my ruling would have a reasonable opportunity to present a petition to and obtain the opinion of the highest court in the state in time for the ballot to reflect whatever that ultimate decision would be. So we're in a difficult spot here. I would like to have the opportunity to consider the arguments of counsel and do a little bit of research on my own that I can do. Fortunately, I do have access to the online legal research devices. The Supreme Court has enabled us to have access to that, which is helpful. But I'd also like to deal with this in a slightly different fashion. I want each of the attorneys here to submit to me a proposed order setting out conclusions of law that you believe are appropriate. And I'd like to have that proposed order submitted to me in Word form and in the form that I can edit it. Because even if I end up agreeing with someone almost all the way down the line, I'm going to find something about the proposed order that I'm not comfortable with and will want to change that. And I want you to attach that as a PDF document and email it to me. I'm going to provide you now with my email address. I've got one of these for each of the attorneys, which we provided for them. This is the tough part. I need it in 24 hours. Okay? I need it in 24 hours. I will commit myself then to jump in, make a decision as soon after that is practicable. And sir, can I fax the order that I go with to you and have you treat it as the original? Okay. So what I will propose...
We have no objection to that.
Okay. What I will propose to do, if you gentlemen have my email address, so I will have yours when you send your submission to me. When I decide what I believe is the right thing to do. And I'm grateful for the fact that this is the trial court level and is subject to review by a higher court. It does have the benefit of a battery of law clerks. I'm going to try to get that to you as quickly as I can so that the matter can properly be presented, hopefully, I hope, to the Supreme Court, so a statewide decision, which is probably what we need here, can be had in a timely fashion. Okay? I know 24 hours is not much time. You do have a lot of your proposed conclusions already. It's a matter of putting them in the format. But it's important to me that it's submitted to me in Word so I can amend it and print it out and when I do submit the order to the clerk, I will try to send an email to all three of you at the same time to give you a heads up, so that you don't have to wait for the mail to come. You can send somebody or come down to the clerk's office, get a copy of the order, decide if you're going to appeal it, and then deal with it. All right? So if we all do our jobs, we ought to have something here by the end of the week that is appealable. All right, well, I enjoyed your arguments, counsel, and I found them to be very good.
Thank you for your service.
Court's adjourned.